Friends, in this program, I will discuss with you some basic ideas concerning human rights, the basic concept of human rights, what these rights are, why they have been adopted at international level, and what is the philosophy behind these rights. You must be reading in the newspapers almost every day. The electronic media tells you sometimes in various news bulletins or otherwise, and also from various non-governmental organizations and activists, you keep on hearing that such and such human right has been violated. State is violating human rights. Or many times you hear that the human rights have become very important in international arena, and protection and promotion of human rights has become an international concern. Naturally, you must be keen that after all, what we understand by human rights, why they have become important, why their violation is treated as something very serious at international level, and why there is always a strong non-governmental civil society movement for promotion and protection of human rights. Well, friends, in fact, concern for human dignity has always been there since the dawn of civilization. In the history of men, we come across various movements, various events, various incidents where persons have fought for their own right to live according to their own wishes. There have been curbs on individuals' self-determination, on individuals' way of life, etc., etc. But the term human rights, in fact, is something which is new. In the 17th century, we start hearing demand for rights. That means individuals have certain rights because they are individuals, and state must give them those rights. But it was primarily the beginning of 20th century, which gave some sort of a recognition to the concept called human rights. In the present day context, it was the United Nations organization which was established in 1945 after Second World War, where the idea of some sort of recognition, or what we call a legal recognition of universal human rights, came into that. The Charter of the United Nations, which came into existence, as I told you, 1945, proclaimed that one of the purposes of the United Nations is to promote and encourage respect for human rights and fundamental freedoms for all. Now, when the United Nations Charter says respect for the fundamental rights and freedoms of all, now the first question comes that what we mean by these fundamental freedoms. Now, this ultimately was explained what we call Universal Declaration of Human Rights, which was adopted by United Nations General Assembly on 10th December 1948. It is on that day that there was adoption of a declaration which is known as Universal Declaration of Human Rights, and that is why on every year 10th December we celebrate Human Rights Day. Now, this declaration is based on a philosophy that there is something called human dignity, which is different from other species. Human beings, they have a life which is entirely different from what we call a general animal life. Human beings are rational, they have conscious, they have logic, they have a thinking faculty, and they have a speaking faculty. Therefore, their life dignity is something different from the animal species. Secondly, human beings are born free and equal. In fact, nature has endowed them with certain specific rights itself. Therefore, these rights belong to human beings irrespective of whether a state, a country, a government wants them or not. So in other words, we can say the concept of human rights derives from human dignity and the inherent worth of a human being. In simple states, we can say whatever adds to human dignity and the fundamental freedom of human is human right. In fact, we also say that human rights are what each human being is entitled to as human being to live a dignified, secure life of his or her own choice. Therefore, human rights are entitlements due to every man, woman and child because they are human. In this, the discrimination on the basis of caste, creed, religion, nationality, place of birth, gender, etc. cannot be taken as any criteria for denial of any human right to any individual. In fact, as I told, human rights are based on the inherent dignity of every human person. This dignity and the rights to freedom and equality which derive therefrom are universal and inalienable. So accordingly, we can say that the concept of human rights has two basic meanings. The first is that inherent and inalienable rights are due to man simply because of being man. They are moral rights which are derived from the humanness of every human being and they aim at ensuring the dignity of every human being. This is also known as the natural theory of rights. Now this theory is based on the belief that human are born free and equal and therefore rights belong to them as human beings right from the process of their birth as human beings. That means these rights are not to be recognized or provided by any state. The second meaning of human rights is that of legal rights. Now this meaning means that the rights are established according to the law creating process of societies, both national and international. The basis of these rights is the consent of the governed, that is the consent of the subjects of the rights rather than a natural order, which is the basis of the first meaning. So you have seen the difference. The first meaning is that rights belong to human beings because they are human beings and these rights are available to them from nature itself. The second meaning says that maybe rights are available by nature but they have to be recognized by the state so that state does not violate or in a way state takes upon itself a responsibility that those rights will be respected. So therefore here the idea is some sort of a recognition of these rights. Now but the human rights activists believe that these rights are natural. Only thing what state has to do is to give a commitment that the state will not violate these rights, and this commitment is expected at two levels. One, at international level, where the international community as a whole, as a community accepts or recognizes these rights and therefore enters into a commitment that the international community collectively will respect these rights and will not allow others to violate these rights. And the second level is what we call a national level or a state level, where every nation or every state has to give this commitment that that state will respect these rights and will not violate these rights. So it is up to that point that we accept that human rights have to be accepted in a legal way. And that is because of this that there came first a universal declaration of human rights, which was a sort of a commitment by all member states of the United Nations, a sort of an acceptance of the idea or vision of human rights. And secondly, there came up various conventions, treaties, which were legally binding on the states, and thereby states enter into an agreement that they will respect these rights and will not violate these rights. Now, there has always been a question that after all, why these rights are needed. Now, this, as I told you, has been a process which has been evolving throughout the period of history. Now, right at every time or every period of history, we find that human life and human dignity have been disregarded and violated. Then also we find that idea of rules common to all human beings without discrimination dates back various centuries. There has been demands at every level in various civilizations. The principle of equality recognized in natural law was long accepted as the course and standard of political rights. Yet there has always been some justification for discrimination. During the 18th century, there developed the idea of legal rights derived from natural rights, constitutionals as rights, those are mentioned in the constitution or recognized legally. But at the same time, still, in spite of those ideas having come, states have kept on violating rights. And therefore, particularly if you see the situations before the First World War, Second World War, during the Two World War, there have been a large-scale violation of rights, both of individuals as well as those of the groups. As a result of that, as I told you earlier, when United Nations came into existence in 1945, it stated in its very preamble that the determination by the people of the United Nations to reaffirm faith in fundamental human rights, in the dignity and worth of human person. If you read the Charter of the United Nations, we find right in the Article 1 of the Charter, it is written that to achieve international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for all without discrimination as to race, sex, language or religion. Then again, you find other articles in the Charter. Now, for instance, Articles 55 and 56, they say members pledge cooperative effort to achieve inter alia universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language or religion. Now, it was in the background of these provisions in the United Nations Charter that right at the time of its establishment in 1945, United Nations Commission on Human Rights was created, and this commission was entrusted the task of drawing up an international Bill of Human Rights. That is what General Assembly of the United Nations expected from this commission. Now, this commission, which was established in 1945 itself, produced a Universal Declaration of Human Rights. This is popularly known as UDHR or Universal Declaration of Human Rights, and this was adopted by the UN General Assembly on 10th December 1948. Now, as I told you, this Universal Declaration tells that what is the philosophy behind human rights, what are the rights which are to be provided, and why should states make a commitment for protection and promotion of these rights. Now, if you see the Article 1 of the Universal Declaration of Human Rights, that makes it very clear that what is the philosophy behind declaration. This Article 1 says that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Therefore, the article defines the basic assumptions behind the philosophy as 1. that the right to liberty and equality is man's birthright and cannot be alienated. And 2, that because man is a rational and moral being, he is different from other creatures on earth and therefore entitled to certain rights and freedoms which other creatures do not enjoy. So therefore, as I told you, that the Universal Declaration of Human Rights is based on this philosophy that rights are available to human beings by birth. They are not to be granted by the states. All that states have to do is to recognize these rights and thereby respect those rights. Now, if you see the declaration, this declaration contains, as I told you, that means the rights which are available to human beings by nature. These are divided by this Universal Declaration of Human Rights in a way, broadly speaking, into 2 kinds of rights. The first refer to civil and political rights. These rights are basically to maintain individuals' freedom as a citizen and also as individuals' right to participate collectively in the political decision making of the state. So therefore, these rights are known as civil and political rights. These include like rights to life, liberty, security of persons, freedom from torture and slavery, political participation, right to property, marriage, and the fundamental freedoms of opinion, expression, thought, conscience, and religion. Also freedom of association and assembly. So as I told you, the basic purpose of civil and political rights is 1, to protect individuals' freedom, his or her own right to act in accordance to his or her own wishes in his or her private life. And second is a sort of a collective freedom for participation in the political decision making of the state, which in very simple words we can say the rights which are basically democratic rights. The other rights, the other division or this part of the type of rights which this declaration contains are popularly known as economic, social and cultural rights. Now these economic, social and cultural rights are basically for what we can say fulfillment of individuals' material and spiritual needs. These are not concerned with property, etc. in that sense, but they are basically for minimum fulfillment of material and spiritual needs. So these rights are what we call in a way which are for a reasonable standard of living, like rights to education, freedom of cultural life, and all these types of rights which are what we call necessary for fulfillment of human spirituality, human existence in a dignified manner. And also the declaration makes it very clear that these rights are universal. Now, for instance, Article 1 expresses the universality of rights in terms of the equality of human dignity, and the second article expresses that the entitlement of all persons to rights set out without discrimination of any kind. Now, these rights, as I told you, in this Universal Declaration of Human Rights, if we talk in philosophical terms, they can be, in a philosophical term, say that what an human requires is freedom from fear and freedom from want. Freedom from fear, that means he or she can live without any sense of fear from state or from private citizens with regard to threats to his or her life, liberty, opinion, expression, thought and religion, etc., etc. Freedom from want means that he or she will get minimum standard of life which is required to live as a dignified human being, for which he or she will not be dependent on others' mercy or others' some sort of a coercion that if you live like this only then you will get these material needs. No, that means he or she is not free to have. So therefore there is a what we call a complementary and supplementary relationship between civil and political rights and economic, social and cultural rights. If a person is not able to live or is not able to sustain his or her life without any fear or compulsion, then that person cannot enjoy his or her civil or political rights. We say that if somebody tells me that you will get food if you vote according to my wishes, that means my right to express my opinion freely is curbed. And why it is being curbed? Because I do not have food enough to live as a dignified person, and thereby I cannot exercise my political rights to vote according to my own wishes. So therefore there is a absolute relationship between civil and political rights and economic, social and cultural rights. Many times there is a debate that which type of rights are important in terms of hierarchy, whether civil or political rights. So therefore many liberal democratic countries, particularly capital countries, they always give preference to civil and political rights. They say that these freedoms are very important. On the other hand, the socialist and communist countries, they give importance to what we call economic and social rights, because they say that survival is the first thing and only then will come and civil and political liberties or freedoms. But the fact of the situation is that both are equally important and both in fact supplement and complement each other. But as I told you that this declaration, that is the Universal Declaration of Human Rights, was basically a acceptance of a philosophy, acceptance of an idea, acceptance of vision. But this is because this was just a declaration, or this remains a declaration, this was not binding on the states. If any state violates these rights, you cannot do anything. So therefore there came up a question that when we are accepting the idea of human rights, then there should be a mechanism, there should be method by which these rights can properly be implemented. These rights can actually be exercised by individuals, and those who are responsible to maintain these rights, they do not violate these rights in any arbitrary manner. So as a result of this thinking, there emerged what we call human rights instruments. This 1948 declaration therefore can be considered, it was the first tier of three-tier objective. The first tier was simply acceptance of a philosophy, acceptance of an idea, acceptance of a theory, and expressing states' commitment to them. The second and third parts of the International Bill of Human Rights, or what we can call this tier, were adoption by the General Assembly on 16 December 1966, the International Covenants. Now these are known as international covenants, which in very simple words we can say some sort of treaties. So these consisted of two covenants: one, International Covenant on Economic, Social and Cultural Rights, and the second, the International Covenant on Civil and Political Rights. So, and also this International Covenant on Civil and Political Rights has two optional protocols attached to that. Now when we say these covenants and earlier declaration, so difference between the two is that the covenants are legally binding treaties. That means upon agreeing to become parties to the covenants, states accept procedures for the implementation of articles, including the submission of reports on their compliance with the provisions of the covenants. Third, although the General Assembly adopted the covenants in 1966, they came into they were implemented only in 1976, when each covenant had been ratified by required number of states, that is, unless 35 states ratified, these covenants were not to come into existence. So by 1976, minimum 35 states had ratified each of these states, and therefore these treaties became binding. But obviously the treaties are binding only on those states who have signed or ratified these treaties. Now, these treaties provide, in fact, set first of all two types of obligations on states. One obligation on the state is what we can call is in the nature of a negative obligation, and the other is in the nature of a positive obligation. When we say negative obligation, that means that states accept the idea that the rights exist already. The rights are available to individuals. All that state has to do is not to violate those rights, not to interfere in those rights, not to hinder in the exercise of those rights by individuals. So here the state's obligation in a way is what we call to respect the rights. So the first obligation of the state is to respect the rights, where state respects the existence of rights, but otherwise state has nothing to do as far as the implementation or exercise of those rights is concerned. So that is the first basic obligation, which we call a negative obligation. Negative because state is being asked not to do certain things. Therefore we say negative. The other is a positive obligation. Now, negative obligation itself is not sufficient. Theoretically we say that it is a restriction on the state not to violate the human rights, but in actual condition, human being cannot exercise all those rights without some assistance. In particular situations, you need an environment, you need some sort of help, assistance, etc., etc., for exercising those rights. So therefore there is a positive obligation on the states, and that positive obligation is to create situations, to create an environment, to provide that necessary situation in which these rights can actually be exercised and enjoyed by the individuals. So both the conventions, that is the Covenant on Civil and Political Rights, as well as Covenant on Economic, Social and Cultural Rights, provide these types of obligations on the states. So any state which accepts these covenants is under obligation A, not to violate these rights, to respect these rights, and B, to create necessary conditions, to create necessary environment in which these rights can actually effectively be exercised and enjoyed. For your information, briefly I'll tell that what these rights are which are recognized under the two covenants. The first is International Covenant on Economic, Social and Cultural Rights. Now here you will find basically the rights are, as I told you, which are primarily fulfillment of minimum material needs of the society and some sort of provision for intellectual or spiritual satisfaction. These rights include right of self-determination of all peoples and their right to freely dispose of their natural wealth and resources. Then second is equal right of men and women to enjoy all economic, social and cultural rights. Then there is right to work, including the right to enjoy of just and favorable conditions of work. So it's not simply to work, but work in a conducive situation. Then right to form and join trade unions. Right to social security, which means that in case you are not able to work, even then your minimum material needs should be available to you. So that is what we call right to social security. Right to family, including the right to protection of motherhood and childhood. So right to family again means that you can marry or not to marry, and then if you are married you can produce children or not produce children, and if you want to maintain a family, that family will be respected and dignity of that family is acceptable. Right to an adequate standard of living and to continuous improvement of living conditions. Right to health, right to education, right to cultural and benefits of science and technology. Now here what you have seen is that what these rights provide us, basically three things. A, that each individual is free to choose his or her own way of life in terms of earning his or her livelihood, living in a family, marrying or not marrying, etc., etc. Second is, state is obliged to provide minimum material needs for a dignified life, and these minimum material needs include even those needs which are not necessarily concerned with, say, food, etc. Now, for instance, right to education, because as human beings we live a dignified life only if we are educated. In fact, if you remember, the Supreme Court of India has given a judgment where it says that right to life also includes right to education, because right to life simply does not mean a animal existence. It requires a dignified life, and dignified life is if you have right to education. So Supreme Court of India said that the right to education is a built right into right to life. So therefore what we say that this convention makes very clear that state is under some sort of obligation to provide. And thirdly, what we find is that the fulfillment of aesthetic, cultural, spiritual aspirations of human beings also need to be recognized, and these should be provided some sort of support by the state. But at the same time, it is equally important to understand that state cannot provide everything at all the times without availability of resources. Also, there is a state obligation towards society as a whole, in addition to its responsibility towards individuals' rights. And this responsibility of state towards society as a whole includes what we call the protection of the security of the state itself. Therefore, while Covenant on economic, social and cultural rights provides state with certain responsibility, it also gives some powers, or what we call some sort of liberty to state to put limitations on these rights. These limitations can be in a way 2-3 types. One is Covenant places certain limitations on the exercise of these rights recognized by it. Many of these limitations flow from the very nature of the rights and the problems involved their implementation by states. First, the Covenant is based on the general awareness that full realization of the rights contained in it would require a high level of economic development in state. Thus, the developing countries are allowed to determine to what extent they would guarantee these rights with due regard to human rights and their national economy. So the word here are two. One is due regard to human rights and their national economy. So what is required is a balance has to be maintained between the two. Now, for example, I say I have a right to education, and your state should finance my education, say up to PhD level, etc., etc., or at every level. But state does not have resources, money enough to provide every individual with these types of facilities. So what state can do is, state can provide money, say, for primary education, as has been done recently in India, that there will be free and compulsory primary education for all. But as far as higher education is concerned, the individuals will have to pay for that. But even in those courses, those individuals who cannot afford, they can be provided some scholarships, subsidies, etc., etc. Similarly, with regard to health care, now naturally state has to take note of the rights of individuals to have a good health. But at the same time, state may not have enough resources to provide all types of health care. So therefore, this Covenant allows states to provide some sort of flexibility, then in what conditions, up to what level the state will provide assistance, the state will create environment, etc., etc. So therefore, a balance has to be maintained between the resources available with the state, and at the same time, state has to respect and recognize the rights of the individuals. Second, states are also permitted to impose limitations of the economic, social and cultural rights subject to two other conditions. That the limitations must be compatible with the nature of these rights. Second is that they must be imposed solely for the purpose of promoting the general welfare in a democratic society. So this does not mean that the state or any group of persons may engage in any activity destructive. Now here again is a question of balance. State cannot say that we have no resources and therefore nothing will be provided. No, state has to provide these limitations only within a limited framework which is justiciable. Yes, actually state does not have. Now for instance, a state is spending a lot of money on arms and then say that it has no money for education. So it means that state is not justifiably using its resources. And similarly, when state says that we are doing everything for the society and therefore individuals' rights, whose the society is? Ultimately society also consists of the individuals. So there has therefore to be a compatibility between the limitations and all. Third, many of the rights such as the right to adequate standard of living and the right to the benefits of scientific and technological advance depend on the international cooperation for their realization. So it's not simply a question of every state being responsible. When we say that international community has accepted this idea of rights, and international community in Universal Declaration of Human Rights has said that these rights belong to all human beings irrespective of their nationality, irrespective of their place of birth, it means it is also responsibility of the international community that these rights are exercised. If in a particular state resources are not available, in a particular state the development is not of that level where these rights can be exercised meaningfully, then it is also the responsibility of the international community to provide assistance, to provide help, to provide resources so that individuals in the other state can exercise those rights. When we say scientific development, now in a society where there is no scientific development, how individuals in that society can exercise or say be benefited unless the international community or the states which have achieved that level of development, they provide them these types of situations. So therefore, the articles 2, 11, 15 and 22, and they all specifically stress the importance of international economic and technical cooperation for full realization of the rights recognized under this covenant. So you have understood here that this international covenant on economic, social and cultural rights basically provide those rights which are important for human beings to live a dignified life, and for that states are under obligation to provide them enough conditions in which their material needs, their spiritual needs, their aesthetic needs can be fulfilled. States can put certain limitations based on their resources, availability of resources, and also in the interest of collective interest of the society. At the same time, this covenant also puts a responsibility on the international community to help those states. Now, second covenant, as I told you, is the rights, the International Covenant on Civil and Political Rights. This covenant, as I already told you, provides the rights for individuals, freedoms, privacy, and also collective rights for participation in decision making. So broadly speaking, these rights are right of self-determination of all peoples and their right to freely dispose of their natural wealth and resources. You might have seen this right is common in both the covenants. It is available in the first covenant on the economic, social and cultural rights, and as well as in this right. Then freedom from discrimination on ground of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. That means all are to be treated equal. Third is right to effective remedy for violations of rights committed by persons in authority. Equal rights of men and women to enjoyment of civil and political rights. So there cannot be discrimination between men and women. Right to life, which is the most important right as far as human rights is concerned. Unless you are alive, you cannot enjoy any other right. Freedom from all forms of slavery and slave trade. Right to liberty and security of person. Right to human dignity. Freedom from civil prison. Freedom of movement and residence. Freedom of aliens against arbitrary expulsion. Right to fair trial. Fair trial means if you are convicted or you are for any offense, then you must be tried by an independent court and in public view. Right against ex post facto criminal law. That means any action which is not a crime today and tomorrow it is declared a crime, you cannot be punished for that if you have committed that act before the enactment of that law. Right to recognition as a person before law. Right to privacy. Right to freedom of thought, conscience and religion. Right to freedom of opinion and expression. Right to peaceful assembly. Right to freedom of association. Right to family life. Rights of the child. Rights to participate in public affairs. Right to equality, and similarly minority rights. So as I told you, these are the rights, and similarly as it was in the case of economic, social and cultural rights, there are limitations on these rights. The most important limitations permitted by the covenant, as seen already, is that all the rights except the 7 irreducible minimum rights can be denied by a state to its people during public emergency and for maintenance of public order, public law, social order, etc., etc. So as such, what we find is that human rights are basically based on the philosophy that all human beings are born equal, free, and therefore they cannot be discriminated against, but at the same time the covenants have provided certain powers to states so that these rights can be limited in the interest of society as a whole, in the interest of security of the state and public order, but that has to be justifiable and quite limited so that ultimately all individuals can enjoy these rights in a free, fair and equal manner. Thank you for that.